Why do you think that you got a life sentence for nonviolent? I mean, let me just be honest. I mean, I see lighter sentences for murder. So why do you think that you got a life sentence for nonviolent drug charge?
Miss Ledoux, the Louisiana Parole Board member, asked a question that I think all of us are thinking and also ask all the time. How is it possible that chomos and murderers get lighter sentences than dealers? I mean, this man was a devil lettuce dealer. He does have one count of dealing Pepsi, so he's not a complete angel, but his other two counts or convictions were for dealing the devil's lettuce. And what happened was is that they said 3 strikes, you're out. The habitual offender bill, they sentenced him to life. He was going to die in Angola, where he was initially sentenced. But because of recent legislation, Act 122, he was given a chance at parole. And now here he is today. So with that, let's jump in.
Mr. Banks, you're classified as a fourth felony offender, currently serving a life sentence. You were sentenced, you're serving a life sentence for attempted possession with intent to distribute marijuana, possession with intent to distribute marijuana, and as a habitual offender, possession with intent to distribute cocaine. You have a parole eligibility date, which has passed. It's October 27th of 2022. You do not earn good time. So is all that information correct, Mr. Banks?
Yes, ma'am.
All right, Mr. Banks, tell us why you're there. Why are you in prison serving a life sentence for dealing and using drugs? What have you done since you've been in prison that you would make you believe we should vote favorably for you?
Well, I have a better insight on life since I've been incarcerated, and I've accomplished my ISET. I have taken several vocational skills as well as other self-help programs. And if given the opportunity, I would like to give back to society what I've taken away. I've grown to know that in selling drugs, I've destroyed a lot of people's lives. Not only my family, but people in the community as well.
Right. And we'll get a little more information from you when we do our interviews. But first, let's hear from Warden Green. Is there anything you can tell us about Mr. Banks?
He's been housed here since 2016. He's currently in medium custody. He doesn't currently have a job due to some duty restrictions, health concerns. He does have numerous vocational classes that he's taken. He has his high school equivalency. He hasn't had a disciplinary report since 2019. I guess the only thing I could say negative about Mr. Banks is he's got numerous aggravated sex offense write-ups, and throughout all of his classes that he's taken, I don't see where he's even attempted to get the sex offender treatment. That's about the only thing I can say negative about it.
Okay, well, thank you. We appreciate it. Mr. Myers, we'd like to hear from the Parole Project.
Yes, good morning, Kerry Myers with the Louisiana Parole Project. We're here on behalf of David Banks today to support his parole. Mr. Banks is serving a life sentence, as you stated, for nonviolent offenses. He would have had a parole hearing in 2022, except that his health, he was actually hospitalized. He had to have surgery. He had to have a second surgery earlier this year, but he is on his way to recovery. Also stated was that he has multiple programs, both vocational and cognitive programs. Mr. Banks, and talking to him just earlier this week, certainly recognizes the fact that while he was not a user, he dealt drugs for money, and he understands fully that the harm that caused to his community and the people that he sold to. He has a supportive parole project. He has a long-term residence here in Baton Rouge. He'll be also connected to us locally because of that. We're prepared to help him through this transition with employment, with the skills that he needs, with the life skills, financial, technology, social norms. He'll be evaluated by our social workers. He's been a member of AANA while he's been incarcerated. He'll continue to do that once he is released, not because he used, but because he understands that his drug dealing harmed people's lives, and he can relate to that. He can actually be a positive force through that. So we'd ask this board to consider Mr. Banks today and grant his parole.
Thank you, sir. Could we hear from Miss Mary Sampson, please?
I'm here.
Yes, ma'am. What would you like us to know about your son?
I believe that in the time that he's been incarcerated, he's learned a lot. He's worked to develop skills that could help him to grow on the outside, and that the things that he's done, I noticed that the growth that he's made in the time that he's been incarcerated has helped him to change a lot of positive in his life. He's changed a lot of attitude about how he felt about what he was doing. And the fact that he really want to make a difference in his life, in the lives of others. That has been a real help for me in knowing that he's really ready to take responsibility for himself, and the support that he will have on the outside that he can lean on and depend on, helping him to grow at this point. I'm here to support him. He has other family members that are here to support him. His sisters are available as well as other family members. I'm very proud of the fact that he's worked to enhance his life, to grow, and to make positive changes for himself. Is there any particular questions that you would like to ask me other than that?
Oh, ma'am, thank you very much for sharing those remarks with us. We'd at this time like to hear from Miss Addison.
Good morning.
Morning. Go ahead, tell us what you want us to know.
At this time, I would love to speak on my father's behalf and advise that I miss him. I've been without a father my whole life. I'm sure you all can see his criminal history. And this has been a tough battle for us. We've been working to try and get him on the right path, and I believe he has made progress. He's done the things that it takes in order to show that he's ready for society to accept him. I'm willing to accept him. He has a home to come home to. He has stability here with us here in Louisiana or in California, whichever he chooses to decide where he wants to be. I just hope that you all could give him just one more opportunity to see what he can do in order to enhance the world here outside those walls.
Okay. Thank you so much. Mr. Banks, your case has been assigned to Mrs. Ledoux. Would you answer her questions?
Mr. Banks,
Yes, ma'am.
what year did you go into prison this last time?
He's worked to develop skills that could help him to grow on the outside, and that the things that he's done, I noticed that the growth that he's made in the time that he's been incarcerated has helped him to change a lot of positive in his life. He's changed a lot of attitude about how he felt about what he was doing. And the fact that he really want to make a difference in his life, in the lives of others. That has been a real help for me in knowing that he's really ready to take responsibility for himself, and the support that he will have on the outside that he can lean on and depend on, helping him to grow at this point. I'm here to support him. He has other family members that are here to support him. His sisters are available as well as other family members. I'm very proud of the fact that he's worked to enhance his life, to grow, and to make positive changes for himself. Is there any particular questions that you would like to ask me other than that?
Oh, ma'am, thank you very much for sharing those remarks with us. We'd at this time like to hear from Miss Addison.
Good morning.
Morning. Go ahead, tell us what you want us to know.
At this time, I would love to speak on my father's behalf and advise that I miss him. I've been without a father my whole life. I'm sure you all can see his criminal history. And this has been a tough battle for us. We've been working to try and get him on the right path, and I believe he has made progress. He's done the things that it takes in order to show that he's ready for society to accept him. I'm willing to accept him. He has a home to come home to. He has stability here with us here in Louisiana or in California, whichever he chooses to decide where he wants to be. I just hope that you all could give him just one more opportunity to see what he can do in order to enhance the world here outside those walls.
All right. Thank you so much. Mr. Banks, your case has been assigned to Mrs. Ledoux. Would you answer her questions?
Mr. Banks,
Yes, ma'am.
what year did you go into prison this last time?
2007.
2007.
Yes, ma'am.
It looks like you woke up and started taking classes around 2013. Is that correct?
Yes, ma'am. Well, I've taken a few, I was taking a few classes at Sensationalize at a few satellite camps. I took a few classes there, and the few that I was able to take when I was in Angola as well, due to the life sentence that I had, I was very limited to the programs that was offered. So I had to take what I could take at the time.
So with the life sentence, why were you trying to take classes?
Well, I felt as though that I needed to better myself. I needed to better myself. I seen that I had destroyed some people. I've destroyed lives, selling drugs. And that's not the way that life was meant to be. Took me a minute. But I see what I done. And I know that I did wrong. I look back and I see children without shoes. And I say to myself sometimes, I might have been that person that took that from them. And I know that I was wrong for doing so because I wasn't raised that way. I was never raised that way to be that person. So I had to make a change in my life. I had to take some type of stand for myself and understand that life is not just surrounded by you. There are other people that you're hurting as well. So I needed to just take a look at myself and just try to bring out what's
In your opinion, I mean, I can read, I have sentencing minutes and I can read what's on the paper. Why do you think that you got a life sentence for nonviolent? I mean, let me just be honest. I mean, I see lighter sentences for murder. So why do you think that you got a life sentence for nonviolent drug charge?
can't really answer that. Only thing I can say that I've been selling drugs and I've had numerous chances. And I feel as though the judge gave me that at that time. He felt that's what I needed right now. I need, because it gave me the opportunity to realize that I'm sitting here with a life sentence, not knowing if I ever get out. But I need to make a change within myself, where I'm at, right here, right now. So through the years I've been incarcerated, I see those changes through programs that I've taken.
It may have been a good thing for you to have been in with that attitude, knowing that you're looking at a lot.
Yes, ma'am.
Okay. So your health is improving, you said?
Yes, ma'am. Thank you, sir.
I don't have any further questions.
So, were you addicted to the money?
I was addicted to the money. I was addicted to it. The money was something that I used for a crutch. And I thought I was doing the right thing, but I knew deep inside me, I knew I was wrong. And
Did you
I,
ever do a paying real legal W-2 job?
yes, ma'am. I've always had a job. I've had plenty of jobs. I have plenty of skills. I'm a cement finisher, roofing, cook. You know, I have plenty.
You just
Yeah.
wanted more.
I've been working all my life. I wasn't raised this way.
Well, now I hear your mom, listening to your mom, I know that's the case. You just wasn't satisfied.
No, I took the street life on my own. My mom never smoked. I've never seen my mom drink. Nothing.
How many children you have?
I have two.
We heard from one. Do you have your daughter? Do you have a relationship with the other
Yes,
child?
ma'am. Yes, ma'am. She's in Houston, in Texas, rather.
So you have
I told her this every week.
California and Texas
Excuse me,
family.
sir.
You have family, Louisiana, California, and Texas.
Yes, ma'am. Yes, ma'am.
All right, I don't see any other questions. I think, what I think about you is that we'd have locked you up a long time when you first got arrested, your very first offense. We wouldn't be looking at you today, probably. Might would have got your attention back then, huh?
It's been a big eye opener for me. It's really happened.
Yep. All right, I think we're prepared, Mrs. Ledoux.
Mr. Banks, you can well imagine the scope of sentences I see before me in this job, and life sentence for nonviolent drug is, you've been in over 16 years. My vote today is to grant parole to the parole project until such time as you make long-term arrangements. I'd like for you to stay there at least 9 months. And then you can make some long-term arrangements where you feel like it's best for you to be. And I would encourage you to continue with AA and NA once a week, at least for the first 6 to 8 months, to keep your mind straight on why you went to prison. Okay?
All right.
I'm going to concur with Mr. Ledoux, but add the condition that you stay out of the high crime areas. And if you don't know where they are, ask your parole officer. They probably still the same as where you used to go.
Yes.
And that you complete 2 days community service per week until you're gainfully employed. If you have a job, you don't have to do the community service work. If you're unemployed, you're going to have to do the community service work. We just don't want you out there with nothing to do.
Yes, sir.
All right, Mr. Banks, my vote is the same, to grant you parole with the special conditions that have been spoken by my colleagues. You understand all those conditions?
Yes, ma'am.
Like to you, sir.
Thank each and every one of y'all for accepting me.
You do realize that on a life sentence, when you paroled, if you mess up, you go back to life.
Now, for those of you asking again, how is it possible he got a life sentence for possession with intent to distribute in the state of Louisiana? And it's because of an habitual offender bill. You see, Louisiana, they like locking up nonviolent offenders for life without ever having the opportunity for parole. Now, I'm going to unpack this case. But before I do, I am going to show you another case that happened today, the same day as this docket, for a man who did the unimaginable to his 8-year-old autistic son for years. And you know what they gave him? The maximum allowed by Louisiana legislation, just 20 years. Now, they could have given him more. They could have slapped on other charges, but they chose not to. And that's the point I'm making here. So let's jump into this second hearing, and then I'll unpack both together to tie it all in. So let's go.
You haven't requested to take it?
I didn't know I had to.
So you don't think you need to?
I didn't know I had to, but,
So you don't think you need to?
well, I probably do, but I know that I've been, I have no desire for any sexual activity. I prayed to God that He'd take that away from me. And so ever since then, I've had no desire for any sex. I just prayed He'd take it away from me, and so I can't even watch this stuff on TV. Anything on TV like that, I just don't even, just turn away, you know.
I don't have any other questions.
Now, this might be hilarious if we weren't talking about one of the worst roaches, the worst chomos that we have ever covered on this channel. We are talking about a monster who was doing this to his autistic son from the age of 8 until the age of 14 when he was finally caught. And yet a judge allowed him to take a plea deal that would wipe out other felony charges that would have set him up for a life sentence. Instead, he gets just 20 years.
All right, Mr. Foster, good afternoon, sir.
That's me.
Introduce yourself. Tell us your name and DOC
My
number.
name is Douglas Foster.
And what's your DOC number?
It's 536-885.
Let me see. Yeah, I was looking at your SID. Yes, 536-885. Thank you, sir. So, Mr. Foster, you're classified as a first felony offender. You are currently serving a 20-year sentence, sentenced in Ouachita Parish in August of 2008 for 1 count of aggravated incest. Parole eligibility is August 15th of this year. You don't earn good time, so your full term date is going to be August 14th of 2028. Does all that sound accurate to you?
Yes, ma'am.
All right. Well, your case has been assigned to Mrs. Ledoux. Before I turn it over to her, I'm going to ask Warden Thompson, is there anything you can tell us about Mr. Foster?
No, ma'am, no comment.
All right. Ms. Ledoux.
Tell me why you're here and why you think we should allow you to get out today.
The reason I'm here is because of incest, and I had possession of marijuana, and I had 2 illegal guns, you know. And that was the only thing they charged me with.
Okay, have you taken sex offender treatment yet?
No, ma'am, I was supposed to in Winfield, but they shut down. I was working as a tutor, so I never got a chance to get around to taking it, and they finally shut the place down.
How long have you been there?
I was there 12 years.
How long have you been at the
I've been
facility?
there, almost 2 years now.
And have you requested to take it?
No, ma'am.
You haven't. You haven't requested to take it?
I didn't know I had to.
So you don't think you need to?
I didn't know I had to, but,
So you don't think you need to?
well, I probably do, but I know that I've been, I have no desire for any sexual activity. I prayed to God that He'd take that away from me. And so ever since then, I've had no desire for any sex. So I just prayed He'd take it away from me, and so I can't even watch this stuff on TV. Anything on TV like that, I just don't even, just turn away, you know.
I don't have any other questions. Sure.
Have you done any victim awareness training?
They supposed to put me in a class, but I haven't done it yet. They haven't put me in the class yet.
No, all right.
That's one thing I do need to take.
Yeah, you had a significant impact on the victim. I think we're prepared to vote, Mr. Foster, Mrs. Ledoux.
I don't see any sex offender treatment, no victim awareness. I just don't believe that you're prepared to be a successful member of society without some of that treatment. My vote is to deny.
Mr. Bauer.
I concur, deny for the same reason.
Mr. Foster, my vote today is also to deny. You're not prepared for release. We also have extensive opposition in the record from the sentencing judge, the district attorney, and law enforcement. So you've got some work to do, Mr. Foster. Today, your parole is being denied.
And what did I say? Have we covered a more disgusting roach than this monster? But wait till I give you the facts. Wait till I drill down into the facts of this case. So we are going to uncover, one, just how disgusting and sick of a monster he is, and two, how the DA dropped the ball on this case. He is getting out on his full term date in 3 years. How is this justice? How is this protecting the community? How is it rehabilitation? It's none of it. He is going to be out there, but don't worry, God has spared him of his sexual desires. And here's the point. This is the point that I'm making. We see it all the time. He was the man before him was the possession with intent to distribute. There's a lot of drama on it. Sir Richard found documents. I can go over it, but basically, he was convicted of a non-unanimous jury. Police officers chased him for his third felony, arrested him, did not find any narcotics on him, but claimed that he had thrown it when he was running away from them. He was then found guilty of a non-unanimous jury and sentenced something like 10 years. And then the DA came and said, you've been arrested 3 times in the past 10 years. That's 3 strikes, young man. We're going to slap an habitual offender bill on you. You're going to get life. And that's what Louisiana did to that man. Now all the kudos to him, all the credit in the world. He turned that frown upside down and somehow made the best of it, and he got rewarded. And man, he is a poster child for that, in my opinion. I don't know what the aggravated sexual write-ups are about. It could have been doing stuff in the shower with him, so I don't know. But I don't think it was anything more than that. But the DA in this case, well, I'll read the thing. Like he said, they found guns that were illegal. He also had possession with intent to distribute. Apparently, he had scales and things, and he had these charges. But when they got him, He was taking pictures of his son. He was taking videos. He had years, from 8 years old, of evidence. They had the royal flush. There was no reason to do any plea deal. They needed to lock him up for life, and they didn't. And I get it. It's different parishes, different DAs, different judges. Maybe DA one would have done it to DA two would have done something differently. But we see it over and over and over again. They do not take these monsters as seriously as dealers. And it's messed up. I don't know how you sleep at night, nor does a DA show up for this case. Can you imagine? This literally, what I'm about to read to you, is probably the most horrific thing that I will read to you in the many cases that we've covered. So you know I'm not exaggerating. I'm sure that the police don't sleep well at night, but yet the DA can't even show his face. On August 20th, 2007, Sergeant Joe Baugh from the Wichita Parish Sheriff's Office received videotape of a 14-year-old juvenile, which was made at the Children's Advocacy Center, where JF stated that his father had been essaying him since 2011. This is since 2001. So this is 6 years straight. I'm talking full-on essay. JF had Asperger's syndrome, which is a high-functioning condition found on the autism scale. JF stated that his father, JF, performed on him, and that his father performed on him. So they performed on each other. Defendant also forced JF to watch videos of adult content and to look at adult magazines with him. And he forced JF to watch him stimulate himself with an electric toothbrush. In addition, the defendant took pictures of him lying on his living room floor with a black cowboy hat over his face. So he's probably trading it, right? He's probably selling it. That they could have gone. I don't know what legislation they had in 2011 for this stuff. 2007 was probably early on, but maybe they didn't have it. I don't know. They couldn't get him on those charges. I don't know. I doubt. I'm sure they had distribution of this stuff, but anyways, it goes on. This is his biological father. Jave stated that his father had a bunk bed for him to sleep in when he came to visit, but the upper bunk was always stacked with possessions, and he had to sleep in the lower bunk with his father. Jave also stated that his father had introduced him, had instructed him not to tell anyone about their activity, because if it were revealed what was going on, he would go to jail. On August 21st, 2007, the Wichita Parish Sheriff's deputies obtained a search warrant. Let me just see how long it took them to get this video to obtain a search warrant. August 20th. Okay, it took a day. Good job. Cops did a good job. And went to the defendant's home in Monroe, Louisiana. When the defendant came to the door, officers immediately noticed a strong odor of the devil's lettuce. A search of the premises produced many weapons found within feet of the devil's lettuce, videos, VHS, DVDs, VHS tapes, adult content, box of homemade and store-bought and store toys. Cameras were located in the living room and were seized by officers, as was a cowboy hat located in one of the rooms. The defendant was arrested and read his Miranda rights. Federal charges were filed against him in possession of the weapon. After his first arrest, the defendant gave a statement to the sheriff's office wherein he admitted performing on JF beginning when JF was 8 years old. So they have video, they have a confession, and admitted that he and his son performed on him. Further, he stated that JF had seen him and watched videos with him, but denied JF watched. He admitted attempting to take pictures of JF while JF was wearing a cowboy hat and a towel, but stated that his camera battery died and he was not successful. Okay. He also admitted to taking JF's ADHD medication because it would cause him to become aroused. On September 21st, 2007, a bill of information was filed charging the defendant with 1, aggravated incest between August 1st, 2001 and August 31st, 2007. So 1 charge for 6 years of abuse. And again, I don't know if they could have done multiple charges or they just choose not to. Indecent behavior with the juvenile. Possession of marijuana with intent to distribute. I'm guessing that it was intent to distribute, that he must have had scales or something. The case was scheduled for trial on April 21st, 2008, and a jury was selected and sworn. After hearing the testimony, Sergeant Bob, the defendant, decided to plead guilty. The charge of aggravated incest with the victim being greater than 13 years of age. So if you're under 13, according to Louisiana legislation, you would get 25 years. If you're over 13, the maximum you could get is 20 years. Those are the maximum, by the way. If you just think about legislation law, they write laws that actually limit what a judge can sentence, which is insane. That's sick. You should be life. Why is a judge the maximum can give is 20? But here's the insanity. They make them go through jury selection. They make the spend all the money on the case and everything. And then when they go to trial and he says, "Oh, I want to take a plea deal," they offer a plea deal. Why would the judge say no? No. And then they allow him to plea to above 13, even though that's not the truth. He was 8. Because they're weak and they're sick and they're pathetic and they do not care. They had every bit of evidence. So jury, you do it. You go to trial. Why else did he become a DA? So you can lock up drug dealers for life? The other 3 charges against him were dismissed. I can't believe it. This is insane. A PSI was ordered, returnable by August 10, 2008. On August 22, 2008, the trial judge examined the PSI report, allowed a statement by the victim's grandfather, allowed the defendant to speak on his own behalf. I can imagine the grandfather probably spoke on behalf of the defendant, and then thoroughly examined sentencing facts. I don't know that, but who knows? The trial judge stated that he found the defendant to be one of the worst offenders. Well, judge, first of all, I would like to know who's worse. But if he's one of the worst, how come you allowed this plea deal? And also noted that the defendant had been spared what amounted to life sentence. Yes, you should have sentenced him to life. I mean, wouldn't that be? This is the thing. People want to make no. This is the man that you sentence him to life for. This is why, if you're a lawyer, a prosecutor, you graduated law school. This is your life mission. What could be more fulfilling than making sure this man never walks in the street again? But he will walk in the street. He'll be out in 3 years. So the judge sentenced him 20 years, which was the maximum. But don't be fooled by. We can all say the legislation is insane. Lawmakers in Louisiana need to change this legislation. It needs to be life. Who would argue against that? And then, and remember, it should be life, period. But all I'm even asking for is to give the judge the option to have a range, minimum of 20, maximum of life. Why? How could you argue against? Why would the law in Louisiana say, "Judge, we don't think you're gonna give a proper sentence. The maximum you can give a father that does this to their son is 20 years." There's something broken in the justice system. So then they have a discussion. This is his appeal. He contends that he did not have a significant criminal record. In fact, his only prior convictions was a misdemeanor conviction of possession of the devil's lettuce in 1978. He helps his elderly parents with their catfish farm, lifting heavy bags of food and moving many acres of pasture, and claims that imposition of maximum sentence will result in hardship to his family. The defendant claims that he is remorseful for his actions and that he apologized to his son for hurting him. The defendant argues that because he had been a law-abiding citizen his whole life, the record in this case contains no evidence of aggravating factors warrant maximum sentence. The test imposed by the reviewing of the court determined the excessive of a sentence is two-pronged. First, the record must show the trial court took blah, 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 blah. We'll keep going. He didn't win the appeal, but there's more interesting information in here. They talk about what the crime is. In the case, they had a copy of the PSI's recommendation. The defendant received a huge benefit from having other charges dismissed. The trial judge considered the defendant had expressed remorse at the sentencing hearing, and it indicated that he had repented his sins. What BS? We saw just how remorseful he is now. Okay. And that he had repented his sins and had a relationship with God that he did not have before. Oh, that sounds familiar too, actually. Is further indicated that he had taken the defendant's previous narcotics and alcohol difficulties into consideration. The aggravating factors considered by the trial judge greatly outweighed the mitigating factors. He stated the defendant had repeatedly and for prolonged periods of time exposed JF to adult content, forced his child to sleep in the same bed with him, forced him to engage in sexual activity with him, stolen his medication, could experience sexual damage his autistic son mentally and emotionally for life. There's the point. Damage his autistic son mentally and emotionally for life. That's the understatement of the century. The trial judge stated that he considered the defendant worse sexual offender because he had tortured his own son sexually for years and mentally, I can't even say these words, a burden to keep the defendant's secrets. The trial judge indicated that his recommended PSI was that the court should impose a maximum sentence due to the seriousness of the substantial benefit the defendant had already received a virtue dismissal of 3 offenses. Why would they dismiss them? It's insane. The trial judge imposed a maximum allowable sentence under the statute. In addition, because the defendant pled guilty to the crime of aggravated, he was not eligible for diminution of sentence for good behavior. I guess that's one good part of the law, no good time. And that was it. That was the conclusion. So, and just to put into contrast from the hearing we saw before this, right? This man, from the hearing we saw before this, let me show you. Mr. Banks, this is from a 39-page report talking about non-unanimous jury verdicts for inmates sentenced to life in prison. So he's in this 39-page report. Similarly, among individuals of non-unanimous jury verdict decision, Mr. David Banks, so this is the man, 53 years old at the time of this writing, a few years ago, who was sentenced to life imprisonment for possession of Pepsi under Louisiana's extreme habitual offender statute. Originally sentenced to 20 years. So again, like we were saying, he was originally sentenced to 20 years, which is the same amount of time that this monster got, that roach got, he gets 20 years. Remember, not a violent offender. And this was for possession, his third felony for possession, not intent to distribute. Possession. The judge sentenced him to 20, and that wasn't enough. The DA said, no, that's not enough, Mr. Judge. So Mr. Banks was charged as an habitual offender after he was sentenced for the 20 years. And then they say, we're going to go back and we're going to sentence you to life without parole. So do you get it? The DA wasn't satisfied with the 20 years. They went back and said, here's this bill, there's paperwork, we're allowed to do this, legislation allows it. 3 strikes, you're out, gone. Life without parole. Mr. Banks' non-unanimous jury verdict, by the way, rested entirely on the testimony of 2 arresting officers who did not find any Pepsi on Mr. Banks. Instead, he claimed he threw it while he was running from the officers. So it wasn't possession with intent to distribute, which by the way, is a little interesting because I guess it conflicts a little bit of what we heard in the hearing, but let's not get stuck in those details. He has such a high quality hearing. I don't think that's relevant. So he's chased down. They catch him. They don't find anything on him. They claim they saw him throw something. A non-unanimous jury finds him guilty. They sentence him to 20 years. How? I don't know. And this isn't even in the 90s or the 80s or whatever. This was in what, 2000, late 2000 and something, 6 or something. And then that was, yeah, I mean, that's in this article. They're just talking about how much it costs Louisiana per year to keep these life offenders locked up. Oh, I just was here. I don't know if I was, but anyways, I'm beating a dead horse. I think we see the point. The point is that there's a few things, right? There's legislation which doesn't allow Louisiana prosecutors to throw away the worst of the worst for life. There are DAs that actually will prefer to go out of their way to put away low level drug dealers, even if you want to, even if you just want to, I mean, forget all the non-unanimous jury and the story of possession, and like it's priorities. It's insane. It's not about even good versus evil, right versus wrong. It's simply like whatever is motivating them. Maybe, oh yeah, we're putting away drug dealers, we're keeping your streets safe. Let's not talk about the evil roach dad. And that's sick. And that's part of why we do this, because this, we're able to see it right there in front of us. You can feel it, you can touch it, you can see the insanity of it. Two different offenders, two different approach to prosecute. And it's so clear to anybody with a pulse that the system is broken. And with that, I'll let you go.
Why do you think that you got a life sentence for nonviolent? I mean, let me just be honest. I mean, I see lighter sentences for murder. So why do you think that you got a life sentence for nonviolent drug charge?